Obligation, collateralization, and foreclosure. Objectives. The objectives of this chapter are to understand the implications of debt payment obligation, how properties become collateral to secure debt, what foreclosure is, as well as the two types of foreclosure. Collateralization and obligation. Securing debt payment. Let me ask you a question. What makes a financially successful institution or individual confident enough to lend, usually to a stranger, a significant amount of money for the purchase of real estate and have the firm expectation that the money will be paid back and with a profit? The reason is simple. In real estate, real property is collateral to monetary debt. In real estate financing, creditors have rights over the properties they finance. This means that the lender has the ability to gain control of subject real property and dispose of it in order to get paid. Obligation, collateralization, and foreclosure are the crux of real estate financing. It is vital to understand obligation, collateralization, and foreclosure. With this knowledge, the complete subject of short sales and foreclosure will be revealed logically and understandably. The concepts of obligation, collateralization, and foreclosure have existed for centuries. These principles are timeless and worth studying. Short sales are about real property that is collateral for a debt. The essence of real estate financing. The essence of real estate financing is the existence of an obligation to pay a debt and the pledge of collateral to guarantee that payment. There is a promise to pay and a penalty for not paying. Thus, there is obligation and collateralization. Obligation. Definition. In finances, an obligation is a legally binding responsibility to pay a debt to another person or entity. In this relationship, the person responsible to pay a debt is the obligor. The obligor pays. The person or entity to be paid is the obligee. The obligee gets paid. There are two types of obligation: involuntary obligation and voluntary obligation. Involuntary obligation. Definition. An involuntary obligation is a binding obligation imposed by the judicial system to enforce the payment of debt. The debtor-creditor relationship is created by judicial decree. This obligation is not necessarily initially associated with collateral. However, it is typically rapidly collateralized if the debtor owns real or personal property. A couple of examples are judgments and tax warrants. This tax warrant is a good example of an involuntary obligation. Voluntary obligation. A voluntary obligation is a contractual and binding obligation voluntarily accepted by all parties to enforce payment of debt. The debtor-creditor relationship is created by mutual agreement. In real estate, collateral is associated with the obligation from the beginning. In real estate financing, a voluntary obligation to pay debt is called a promissory note. Promissory notes. Definition. A promissory note is a legal instrument that contractually seals and records a voluntary obligation. In a promissory note, a debtor makes an unconditional written promise to pay to a creditor a certain amount of money in a specific time frame. It creates a contractual relationship between a debtor and a creditor. In this relationship, the debtor is the promisor and obligor. The debtor promised and therefore is obligated. The creditor is the promisee or obligee. The creditor was given a promise, so there is an obligation to the creditor. This is a good example of a well-drafted, commercially available promissory note. This image shows the same document, properly executed and legally binding. Here is the principal or face value of the debt, the location, and date the note was created, as well as the date on which the debt is due. Here the debtor promises by reciting "we jointly." Jointly means the promisors together, and severally. Severally means the promisors separately or individually. For example, if a couple divorces. Promise to pay. Promise means unconditional obligation. To the order of the creditor's name. This promise establishes the debtor as the promisor and the creditor as the promisee. This is the principal, $10,000. The terms of payment are interest of 12% per annum from December 3, 2002 until paid, with interest to be paid in a lump sum. Since this is real estate, the collateralization instrument is invoked. This note shall be secured by a trust deed. In this example, the debt is secured by a trust deed. It could have been secured by a mortgage. In addition, by description, reference is made to the collateral securing the debt. The date the debt is due is further stated. With their signatures, the debtors become legally bound to fulfill their obligation to the creditor. Foreclosure. Foreclosure is the extinguishing of the rights of an owner and other secured parties in order to satisfy a lien. The collateral is sold in order to pay an obligation. Most foreclosures are accomplished by trust deed execution or mortgage execution. Collateralization. Definition of encumbrance. An encumbrance is a binding legal claim attached to real estate. An encumbrance affects or limits the rights of an owner over a property. It does not necessarily have to do with money. Examples of encumbrances are rights of way, setbacks, height limitations, zoning ordinances, and CC&Rs. Definition of lien. A lien is a voluntary or involuntary encumbrance against a property for money. In a lien, the property is collateral to debt. Since the property is collateral, the creditor has a binding legal claim attached to the property. The claim must be paid when the property is sold. Examples of liens are judgments, mortgages, trust deeds, and taxes. Collateral. Definition. Collateral is a marketable real or personal property that a person commits either voluntarily or involuntarily as security for debt payment. Default triggers the sale or repossession of the collateral. In real estate, the sale of the collateral is called a foreclosure. The proceeds of the sale are used to pay for the debt. Types of liens. There are two types of liens, voluntary lien and involuntary lien. Involuntary lien. An involuntary lien is a lien on the property of a debtor resulting from a court decree. The owner has no choice. The lien is imposed on him by the judicial system. Examples of involuntary liens are child support, contractor liens, judgment liens, city and county tax liens. Voluntary lien. A voluntary lien is a lien in which an owner voluntarily pledges real property as debt security. The owner has a choice. He voluntarily elects to have a lien on the property. Examples of voluntary liens are mortgages and deeds of trust. Types of foreclosure. There are two types of foreclosure, judicial foreclosure and non-judicial foreclosure. Judicial foreclosure. A judicial foreclosure is a foreclosure by lawsuit. In a judicial foreclosure, the lender sues the homeowner for breach of contract. The homeowner becomes a defendant. Although it can take a long time, because default is easily proven, the court rules in favor of the lender. The property is sold by the sheriff in a sheriff's sale. Judicial foreclosures are subject to all kinds of legal complications. Most judicial foreclosures have redemption periods. These vary from state to state. Liens and most mortgages are foreclosed judicially. Power of sale. Although non-judicial foreclosures have been the norm for decades in many states, in a large portion of the country, judicial foreclosures are still prevalent. To comprehend how non-judicial foreclosures work, it is critical to understand the concept of power of sale. Power of sale is a mortgage or trust deed clause in which a debtor pre-authorizes the sale of the collateral in case of default. The creditor has a contractual right to sell the property if the obligation is not satisfied. Because of this, the property can be sold without any judicial action. In order to invoke the power of sale, the clause must be drafted in the collateralization instrument. Non-judicial foreclosure. Non-judicial foreclosure is the sale of a property under a power of sale clause. No judicial action is required. Unless poorly drafted, all trust deeds have power of sale. Few mortgages have a power of sale. Trustees or foreclosure attorneys execute non-judicial foreclosures. Non-judicial foreclosures are subject to very few legal complications. The majority of non-judicial foreclosures are final. Typically, there is no redemption. Trust deeds and mortgages with power of sale are foreclosed non-judicially. Review. Debt payment obligations are unconditional. Debt payment obligations are either voluntary or involuntary. In real estate, debt payment obligations are secured by collateral. Liens convert real estate into collateral. Foreclosure extinguishes the rights of the collateral's owner. Properties can be foreclosed judicially or non-judicially. Mortgages and mortgage foreclosure. Objectives. The objectives of this chapter are to understand how mortgages work and their foreclosure process. Mortgage. Definition. A mortgage is a voluntary collateralization instrument in which a debtor pledges directly to a creditor real property as collateral for performance of an obligation. A mortgage creates for the creditor a lien and other legal rights over the property. The main legal right a mortgage creates is, in case of default, to have the ability to cause the sale of the property for obtaining the funds to pay off the obligation. To cause the sale of a property is called execution of mortgage. Execution of mortgage is foreclosure. An example of other legal rights a mortgage creates is the assignment of rents. This clause is drafted into most mortgages. In case of default, the creditor can collect rents directly from tenants. Another example is due on sale. This clause allows the creditor to demand full payment as soon as the property is sold. In its most pure and theoretical form, this is how collateralization by mortgage works. An owner, legally referred to as the mortgagor, needs capital, owns property, and wants to use the property as collateral. This property belongs to the owner. As a premise, the owner holds insured title or insurable title. No experienced lender will lend on a property without an insurable title or title insurance. A lender will loan money to the homeowner. From this point on, the lender will be referred to as the mortgagee. To ensure payment of that debt, the owner will commit the property as guarantee of payment to the lender. Said in other words, the mortgagor pledges the property as collateral to the mortgagee. At this point, the property becomes collateral. There will also be an obligation instrument. This usually comes in the form of a separate promissory note. It is very common to have the promissory note written within the mortgage document itself. They do not always have to be separate documents. If this loan is the result of a refinance or sale, new title insurance will be issued by a title insurance company. Very often, the title company will also handle the escrow. Thus, many title companies use title and escrow as part of their name. In many states, escrow services and real estate closing are done through attorneys. The main function of the title company is to insure title. Since most mortgages are foreclosed judicially, upon default, the mortgagee will sue the mortgagor. The lawsuit is mortgagee versus mortgagor, and because it is a lawsuit, the judicial system is invoked. For that, the mortgagee will employ a foreclosure attorney. The attorney initiates a lawsuit for breach of contract. Since default is easily proven, the court will instruct the sheriff to execute the mortgage. Thus, the collateral property is to be foreclosed judicially through a sheriff's sale. Mortgage types. There are two types of mortgage, the common mortgage and the power of sale mortgage. The second one has a power of sale clause. Mortgage foreclosure. Mortgages can be foreclosed either judicially or non-judicially. Mortgage judicial foreclosure. In a mortgage judicial foreclosure, the mortgagee employs a foreclosure attorney. The first action the attorney will take is to send a notice to cure or notice of default. The specific name of the documents varies. This document is a demand for reinstatement within a specific time and an announcement of pending legal action. Pending legal action is also known by the Latin name lis pendens. If the default is not cured, the mortgagee will sue the mortgagor in a mortgagee versus mortgagor legal action. If default is proven, the court will approve the sale of the pledged collateral through a writ or decree of mortgage execution. The sheriff will be instructed to sell the property at a sheriff's sale. Mortgage non-judicial foreclosure. Only mortgages with power of sale clauses can be foreclosed non-judicially. The creditor will employ a foreclosure attorney or paralegal service, but no legal action is needed to execute the mortgage. Depending on the state, an attorney, commissioner, or similar professional will sell the property. Mortgage payoff. The origin of the word mortgage says it all. The term mortgage comes from the Old French words mort, which translates to dead, and gage, which translates to pledge. Thus, the word mortgage means a pledge that is dead when the debt is paid. Mortgages extinguish when the secured obligation is performed. That means debt payoff ends mortgage. In most states, the instrument that demonstrates the performance of obligation and extinguishing of the mortgage is called full satisfaction of mortgage. Other commonly used names for this document are release of mortgage and execution certificate of release of mortgage. All states have heavy penalties for not releasing a mortgage after debt payoff. Let's analyze a common mortgage. This is the mortgage without power of sale. This is a good example. Mr. and Mrs. Homeowner, from now on referred to as mortgagor, in consideration of a certain amount of dollars, convey unto Mr. Big Bank, now referred to as mortgagee, the following described premises. This is the collateral. Collateral description. It continues. This mortgage is intended to secure payment of one or more promissory notes. If the sum of money due upon the note and this mortgage shall be paid according to the agreement herein expressed, this conveyance shall be void. This means that at debt payoff, the mortgage will no longer exist. In case of default, the mortgagee may foreclose and sell the premises. Foreclosure course of action. This is the foreclosure course of action the mortgagee will take. It reads, in the event of any suit or action to foreclose, the mortgage is commenced. This means there will be judicial action. Judicial action means judicial foreclosure. The losing party agrees to pay. These three lines cover all potential foreclosure expenses. All such sums shall be and are secured by the lien of this mortgage and shall be included in the judgment or decree of foreclosure. This means that if foreclosed, the mortgagor pays all foreclosure expenses. This mortgagee can only foreclose judicially. There is reference to legal action and no power of sale clause. In case of default, the mortgagee will receive a notice of default or notice to cure. The specific name of the document can vary somewhat depending on location. Here's a good example. It reads, you are now in default. Correction of this default must be made. If you do not correct your default, we may exercise our rights against you under the law. This means that the attorney representing the creditor will commence a lawsuit. A lawsuit is needed to sell the property because there is no power of sale clause in the mortgage. Therefore, the only way to foreclose this mortgage is judicially. That is why it says, "We may proceed with suit against you." This is the threat of legal action. Threat of legal action indicates pending judicial foreclosure. Power of sale mortgage. A power of sale mortgage is a mortgage that contains a power of sale clause. This type of mortgage is not new, and it is becoming more and more common. Let's analyze this sample. It reads, "This security instrument secures to lender the repayment of the loan. For this purpose, the borrower does hereby mortgage, with power of sale." No legal action is needed, means non-judicial foreclosure. With a power of sale mortgage, in case of default, the debtor typically receives a notice of default and election to sell. This is commonly known as the NOD. Other terms, such as notice of breach of contract, are often used. This varies per each state's statutes. The document reads, "Reference is made to that certain mortgage made by Mr. and Mrs. Homeowner, the name of the debtor, as mortgagor, to Mr. Big Bank, the name of the creditor, as mortgagee. The undersigned gives notice that a breach in the obligation secured by the mortgage has occurred. If the obligation is not cured, the mortgagee has elected to sell the property under the power of sale. The proceeds of the sale will be used to satisfy the obligation. Power of sale means no legal action required. This will be a non-judicial foreclosure." Satisfaction of mortgage. When the debt payment obligation is fully performed, the validity of the mortgage expires. The instrument that demonstrates the debt payoff and end of pledge of collateral is called a satisfaction of mortgage. Let's analyze this sample. It reads, "Mr. Big Bank, as owner and holder of the obligation hereinafter described, does hereby certify and declare that a certain mortgage dated, date of mortgage, made and executed by Mr. and Mrs. Homeowner as mortgagor to Mr. Big Bank as mortgagee, that the debt thereby secured is fully paid, satisfied, and discharged." This means the debt is paid off. The mortgage has ended. Review. In a mortgage, a debtor pledges real property as collateral directly to a creditor. In case of default, the creditor can foreclose. Judicial foreclosure is foreclosure by lawsuit. Non-judicial foreclosure is foreclosure with no legal action. Non-judicial foreclosures require power of sale. The mortgage disappears at debt payoff. Trust deeds and trust deed foreclosure. Objectives. The objectives of this class are to understand how trust deeds work and their foreclosure process. Trust deed. Definition. A trust deed is a three-party collateralization instrument. In this arrangement, the debtor transfers land title to a third party as security for an obligation to a creditor. Another name for trust deed is deed of trust. Deed of trust and trust deed are synonymous terms. A trust deed creates a lien and other rights over a property. The main legal right a trust deed creates is the ability to cause the sale of the property for obtaining the funds to pay off the obligation. Causing the sale of a property is known as execution of trust deed. Execution of trust deed is foreclosure. An example of other legal rights is the assignment of rents. This clause, which is included in most trust deeds, allows the lender, in case of default, to collect rents from tenants. Another good example is due on sale. This clause allows the creditor to demand full payment as soon as the property is sold. Trust deeds are the collateralization instrument of choice on the West Coast. They have been used for decades. Because of their effectiveness, trust deeds are now common in many other states. Trust deed parties. Trust deeds are a three-party collateralization arrangement. The owner of the collateral property is the debtor, trustor, and grantor. A title company or attorney is the trustee and grantee. The creditor is the beneficiary. Workings of a trust deed. These are the workings of a trust deed. There is a property owner. From now on, this person will be the trustor and grantor. This person owns a property to be used as collateral. The property belongs to the owner. As a premise, the owner must have title insurance or insurable title. The owner will get a loan from a lender. From now on, the lender will be the beneficiary. The fact that the lender loans money to the property owner establishes a debtor-to-creditor relationship. In order to secure payment, the creditor will demand security for the performance of the obligation. For that, a trust will be formed, thus the term deed of trust. The trustee in this trust will typically be an attorney or title company. Most states require that the trustee be a licensed attorney in the state where the trust deed is created. The trustee will also be the grantee. This will typically be created through an escrow service or title company. It can also be done by a real estate attorney. In this trust, the trustor will grant the property in trust to the trustee with power of sale. The trust is to the benefit of the lender. Thus, the lender is the beneficiary of the trust. This is called beneficial interest. It is at this point that the property becomes collateral through trust deed. The obligation to pay will be documented in a promissory note. Title insurance will be issued by a title company. In case of default, typically the lender will appoint a successor trustee. Successor trustees are typically companies in the business of executing trust deeds in default. If default is not resolved, the trustee will execute the trust deed in a trustee's sale. Trust deed foreclosure. Unless poorly drafted, all trust deeds have power of sale. Trust deeds were designed for non-judicial foreclosure. However, it is the option of the beneficiary. Trust deeds can be foreclosed judicially or non-judicially. With trust deeds, non-judicial foreclosure is typical. Non-judicial foreclosure of trust deeds is by far the most common option. In fact, judicial foreclosures of trust deeds are highly unusual. Because of this, we will only analyze non-judicial foreclosure of trust deeds. Succession of trustee is typically the first step. Second, the debtor receives a notice of default letter, the NOD, from the trustee. In some states, a separate document, the Notice of Trustee Sale, NOTS, with the sale date is required. If the debtor reinstates the obligation, a notice of rescission or similarly named document will be issued. Trust deed foreclosure culminates in trustee sale. If the obligation is performed and satisfied, which means total debt payoff, the trustee will issue a deed of reconveyance. This instrument records the payoff of the debt and extinguishment of the trust deed. All states have heavy penalties for not recording the reconveyance within a specific time. Trust deed. Let's analyze how a trust deed works. This is a good example of a short-form trust deed. It reads, "This trust deed, made on, date of origination, between Mr. and Mrs. Homeowner as grantor, Mr. Attorney as trustee, and Mr. Big Bank as beneficiary. Grantor irrevocably grants to trustee, in trust, with power of sale, the property, collateral property. Power of sale means non-judicial foreclosure. Appointment of successor trustee. In case of default, if the beneficiary decides to begin foreclosure, a successor trustee will be appointed. This is a good sample document. It reads, "Know all by these present that Mr. and Mrs. Homebuyer is the grantor, Mr. Attorney is the trustee, and Mr. Big Bank is the beneficiary under that certain trust deed, dated date of origination, the undersigned hereby appoints Mr. Foreclosure Attorney, this is the foreclosure trustee, as successor trustee to have all the power of the original trustee effective immediately. This includes the power of sale. The successor trustee can now sell the property. Notice of default. After succession, the successor trustee will record the NOD. This is a good example. It reads, Notice of default and election to sell. Reference is made to that certain trust deed made by Mr. and Mrs. Homeowner as grantor to Mr. Attorney or Title Company as trustee in favor of Mr. Big Bank as beneficiary, covering the following real property. Collateral property description. This is the collateral property to be sold. It continues. There is a default by grantor, owing an obligation, secured by the trustee, which authorizes sale in the event of default. This invokes the power of sale clause. It continues. The beneficiary and trustee, by reason of the default, have elected to foreclose the trust deed, and to cause to be sold at public auction to highest bidder for cash the described property, to satisfy the obligation secured by the trust deed and expenses of the sale. Notice of trustee sale. In most states, the notice of default is sufficient and contains the trustee sale date. However, in some states, such as California and Nevada, the NOD does not contain the trustee sale date. In those states, the notice of trustee sale indicates the trustee sale date. This is a good example of a notice of trustee sale. Notice of trustee sale. This paragraph is the reference to the trust deed and collateral. Then it reads, the undersigned trustee will, on date of trustee sale, at the hour of, time of sale, at, location of trustee sale, sell at public auction to the highest bidder for cash the real property described above. Rescission of notice of default. If the default on the loan secured by the property is cured, the foreclosure process will be rescinded, which means stopped. With this, the loan will be reinstated. The document that serves as evidence of this is the rescission of notice of default. Other similar names are used for this document. This paragraph is the reference to the trust deed and collateral. Then it reads, by reason of the default being cured, the notice of default has been removed, paid, and overcome, so that the trust deed should be reinstated. This means no foreclosure. Deed of reconveyance. Once the debt is paid off, the document that demonstrates the performance of the obligation is the deed of reconveyance. This extinguishes the trust deed. This is a good example. It reads, Deed of reconveyance. The undersigned trustee, under that certain trustee dated date of trust deed origination, executed and delivered by Mr. and Mrs. Homeowner as grantor, conveying real property, collateral property. This is the property used as collateral. It continues, that the obligation secured by the trust deed has been fully paid and performed. This means that the debt is paid off. The trust has ended. No more trust deed. Review. A trust deed is a three-party collateralization instrument. Deed of trust and trust deed mean exactly the same. The parties are the trustor, trustee, and beneficiary. Unless poorly drafted, all trust deeds have power of sale. Because of this, trust deeds are typically foreclosed non-judicially. Trust deed foreclosures are typically executed by trustees at a trustee sale. Statutory liens. Objectives. The objectives of this chapter are to understand how statutory liens are created, how they work, and the different types of liens that exist. Statutory liens. Definition: a statutory lien is a monetary encumbrance granted to a creditor on a debtor's property by statute of law. Statutory liens are involuntary. They are imposed by the legal system. The creditor-debtor relationship is established by legal action. Statutory liens tend to be the result of taxation, thus tax lien, or be a judicially imposed financial obligation, thus judgment lien. Types of statutory liens. General statutory liens are liens on all of an individual's assets regardless of type and location. A good example is IRS liens. IRS liens are general. Specific statutory liens are liens on a specific property. A good example of this is a local tax lien on a particular property. We will cover the short sale implications of liens later. There are a large variety of lien types. Here are a few lien examples. Construction lien, judgment lien, city property tax lien, county tax lien, state tax lien, IRS lien, State Department of Revenue lien, child support lien. Statutory lien foreclosure. Statutory liens always foreclose judicially because there is no power of sale. As with most judicial foreclosures, the foreclosed owner can redeem. Property tax liens, such as from state, county, and city governments, can and tend to expedite foreclosure by levying or seizing a property rather rapidly. The specific actions and legal terms used vary by jurisdiction. However, these institutions tend to wait a long time before taking action. Seizing or levying does not necessarily imply taking possession. Because of legal costs, judgment liens are much harder to foreclose. If a statutory lien actually gets foreclosed, it is done through a sheriff's sale. Debt payoff. As with all types of liens, statutory liens only last until debt payoff. The satisfaction of judgment is typically the instrument of choice to demonstrate the payoff and end of a judgment lien. The name of this document varies somewhat per jurisdiction. The satisfaction of lien is typically the instrument of choice to demonstrate the payoff and end of most other types of liens. There are all kinds of liens. They all work similarly. These are examples of the most common types of lien related to short sales. Claim of construction lien. This is the result of unpaid builder fees. This example concerns an original contractor. This is typically for new construction on bare land. It reads, Mr. Construction Contractor, the claimant, did on the date of the contract enter into a contract for work on the collateral property description. The property where work was done is claimed as collateral. The person just named had knowledge of the construction. The claimant fully completed the contract. This is so far a claim, not a resolved lien. However, it may already be a recorded encumbrance. Claimant claims a lien on the land upon which the improvement is constructed, to be determined by the court at the time of the foreclosure of this lien. Mentioning the court invokes legal action. This means judicial foreclosure. Satisfaction of construction lien. If this claim gets paid, the creditor will issue a satisfaction of construction lien. This proves debt payoff. It reads, Satisfaction of construction lien. The undersigned hereby certifies and declares that that certain construction lien has been fully paid and satisfied and is hereby discharged. This demonstrates the end of the lien. Judgment lien. Judgment liens are the result of disputes resolved by legal action. The typical document used is the lien record abstract, or similarly named instrument. It reads, Lien record abstract. There is a judgment creditor and a judgment debtor. The body of the lien states the creditor/prevailing party, under a judgment. Judgments are imposed by the judicial system. The next statement names all that is taken as collateral. It reads, the real or personal property to be affected is all the real property of the debtor in any place county. This is a general lien because it is all-inclusive. However, they usually do not end there. It continues. The following described real or personal property of the debtor. This makes the lien also specific. Then they add the description of the personal and real property taken as collateral. Satisfaction of judgment. At debt payoff, a full satisfaction of judgment is issued. This is a good example. It reads, full satisfaction of judgment. For valuable consideration, full satisfaction of that certain judgment is hereby declared. This means end of lien. Satisfaction of lien. There are all kinds of other liens for all kinds of reasons. After debt is paid, liens securing paid debt are eliminated by satisfaction of lien. This is a generic satisfaction of lien example. It reads, satisfaction of lien. They all have similar wording. The undersigned hereby certifies and declares that that certain lien has been fully paid and satisfied and hereby is discharged. This means end of lien. Review. Statutory liens encumber property to secure debt. This type of encumbrance is involuntary because it is imposed by law. There are multiple types of liens. We analyzed lien documents and documents demonstrating debt payoff and elimination of lien. Title deeds and ownership. Objectives. The objectives of this chapter are to be able to quickly identify title complications in a short sale transaction, to understand the title issues affecting the marketability of a property, to avoid creating transactional complications that may slow or even terminate a transaction, and to understand that the best way to accomplish this is by dominating the subject of ownership over a property. Foreclosure and title problems. A pending foreclosure is a title problem because unpaid secured creditors can exercise rights over a property. If default continues, ownership rights will be affected. Properties themselves do not create foreclosure problems. People create foreclosure problems. A property's title condition reflects the state of the relationships among the people with interests over the property. Properties are in foreclosure because people are not cooperating. Title documents reflect people's state of agreement or disagreement. All this hinders the marketability of a property. Dealing with properties in foreclosure means dealing with people and title problems. Divorce is a good example. A couple has marital problems. As a result, one spouse stops contributing towards the home loan payments. A creditor is no longer getting paid. Now there are 3 people in the situation. One spouse disagrees with selling. If there is a buyer, no title insurance will be issued unless both sign. Lenders do not finance properties without title insurance, so the property can't be sold. Thus, people problems create title problems. Title and deed. The best way to resolve and prevent further problems is to understand the title, deeds, and ownership. Title. Title is the right of possession or ownership of real property. An owner is entitled to his or her property. The owner has title to it. Title is not a document. Title is a legally enforceable right. Title is granted from one party to another. Title to property includes legal responsibilities. Title deed. A title deed is a written instrument that transfers title of land from one party to another. Title deeds are commonly referred to as just deeds. To simplify, a deed is written evidence of ownership. To be valid, a deed must be correctly drafted. Although disputes may arise, destruction of the deed does not affect title. The deed is a document. The title is a right. Deed recording is not essential to validity, but the loss of an unrecorded deed may result in loss of title. For the deed to be validly recorded, it must be properly entered in the chain of title. Chain of title. Chain of title is the historic sequence of title transfers of a property. It is called a chain of title because it shows the connected lineup of owners in chronological order and how much was paid for the property. The chain of title also shows the complete history of encumbrances. In the U.S., complete chains of title go all the way back to the formation of the colonies or the federal annexation of the land. A deed invalidly recorded in the chain of title is called a wild deed and rarely affects present title condition of a property. Title defects are unresolved claims evident in the chain of title. Title defects are also called title clouds. For example, statutory liens are title clouds. Title clouds affect title insurability. If there is enough risk, and it does not have to be much, title companies may consider the title uninsurable. Properties with uninsurable title lose marketability and value because lenders do not consider them reliable collateral. Title insurance. Title insurance is an insurance against loss caused by title defects. It is a guarantee of rightful ownership. Title insurance protects against past title defects as per the date the policy is issued. It covers both the owner and the lender. An owner with title insurance over a property is said to have marketable title to it. Marketable title is one that can be sold reasonably free of litigation. Lenders finance only properties with marketable title because they are good collateral. Lenders and chain of title. In addition to requiring title insurance, lenders closely scrutinize chain of title for two main issues: short-term ownership, which is called seasoning, and large resale price difference. As of the date this material was produced, November 2007, lenders that resell debt to the FHA require a minimum of 90 days ownership between sales. In addition, some lenders will not finance properties with combined short-term ownership and a large purchase price difference. Investors owning short-term must avoid this potential impasse by identifying a buyer's source of funding early. Seasoning problems tend to kill transactions at the last moment. Three important terms commonly used in the short sale business are title condition, deeding a property, and subject to. Title condition. Title condition is the present state of ownership and interest over a property. The present title condition is often not the same as at issuance of the title insurance policy. Any new encumbrance recording is a change of title condition. Examples of change in title condition are a second mortgage, an NOD, and ownership transferring by deeding. Deeding of title. It is the transfer of title over a property outside of escrow and without issuance of new title insurances. This is often referred to as getting the property deeded or getting the deed. The intention of getting the deed is to purchase the property subject to. This means that the owner changes, but the existing financing remains in place. The arrangement is typically that the new owner will keep and pay the existing mortgage. In principle, there is nothing wrong with taking a property subject to, but it has to be done right because there are risks for both the seller and the buyer. Deeding of title, seller risks. Loss of ownership and control. Continued legal obligation to perform on the debt secured by the property because the loan is still in his or her name. Reliance on the buyer as a new owner for paying the loan. If the buyer defaults, the seller will be foreclosed. Buyer risks. Legal liability for anything that may happen to, on, and in the property. A creditor may call the loan. Most loans have a due on sale clause, meaning that the debt may be called due upon ownership transfer. If this happens, the new owner may have to sell in a hurry to avoid foreclosure. This subject is covered in more detail later. Some sellers do not take this type of sale seriously and change their mind. This can result in litigation. Finally, there is no title insurance. Short sale title problems and solutions. Title red flags. There are three main title red flags in the world of short sales: unprofessional title transfers, divorce-caused title transfers, amateur title holding trusts. Unprofessional title transfers. In principle, there is nothing wrong with purchasing subject to existing financing. In fact, it is a common and effective exit strategy, which will be presented in detail later. However, often when short sales are needed for properties that have been taken subject to, it is because of unprofessional behavior. This is often the result of an amateur investor's miscalculation or unscrupulous investors. The actions of difficult original owners are also a cause. The solution to this is to, if there is time, undo the entanglement. This means, as much as possible, to take title back to the original condition, then start the short sale. If there is less than 100% cooperation, do a different project. Divorce-caused title transfers. When a couple separates, their relationship is reflected in the title condition of the property. Typically, when a couple divorces, as a result of the divorce settlement, one spouse keeps the property and the other quitclaims the property. And quite commonly, the property does not get refinanced. They are both still obligated to the loan they committed together. As a result, now they are both in foreclosure because one of them defaulted. The solution to this is to have both spouses collaborate 100% with the short sale because both are in foreclosure. Often bitterness will get in the way. If there is less than 100% cooperation, do another project. Amateur title holding trusts. Title holding trusts are used for controlling properties. In principle, there is nothing wrong with trusts. However, trusts created by amateurs can irreversibly cloud a title. That is often the reason title companies refuse to insure title on such properties. The solution to this is to unravel the trust. This may require expensive legal services. Again, if there is less than 100% cooperation, do another project. One of the best ways to understand title documents is to analyze them. For more information, consult a real estate dictionary. Owner's policy of title insurance. This is an owner's policy of title insurance. By the way, there is also a lender's counterpart to this document. Owner's policy of title insurance. Most title insurance covers the following: title to the state or interest, in other words, challenges of ownership, defects in lien or encumbrance, marketability of title, lack of access. Warranty deed. In warranty deed, the seller legally assures to the buyer that the title conveyed is good and possession will be undisturbed. There are several types of warranty deed variations. This sample is a special warranty deed, statutory form. Bargain and sale deed. In a bargain and sale deed, the seller does not provide any warranties to the buyer. Grant deed. Grant deeds are mostly used in California. The seller warrants that the property was not sold to another buyer before or at the same time. In short sales, usually the presence of partnership deeds, interspousal deeds, quitclaim deeds, and other similar instruments indicates potential disagreements between owners. This is an estoppel deed, also known as deed in lieu of foreclosure. Estoppel deed. Estoppel deeds are often misunderstood and thus misused. Estoppel definition. An estoppel is the prevention of one from asserting a legal right because of prior actions inconsistent with the assertion. This is how an estoppel deed works. In an estoppel deed, or deed by estoppel, the owner grants the property to the foreclosing creditor. If the creditor becomes the owner of the property, the creditor is prevented from foreclosing. Thus the term deed in lieu of foreclosure. Only creditors can get a deed in lieu of foreclosure. Estoppel deeds are often misused. For example, and this is almost unbelievable, but it happens, a homeowner may estoppel deed a property to a buyer so that the other person gets foreclosed. This is a good estoppel deed example. It reads, estoppel deed, mortgage, or trust deed. For the cancellation of the notes and the indebtedness secured by the mortgage or trust deed, the first party does hereby grant unto the second party the following real property. This means that in exchange for debt cancellation, the property owner grants ownership to the creditor. Review. To have title to a property means to be the owner. A deed is a document that demonstrates ownership. Foreclosure is a title problem. People's relationships affect a property's title condition. Title condition affects the marketability of a property. The most common title problems are unprofessional title transfers, divorce cause transfers, and amateur title holding deeds. Most title problems are resolved by fixing people's problems. Invest in solving title problems only if there is 100% collaboration. There are several types of deeds.